lower division bench. Therefore, the term intra-court appeal is a contradiction in terms. No original jurisdiction except in 6 High Court. Another most important aspect to be taken note of is that out of the 24 High Courts established in different states, only 6 High Courts have got original civil jurisdiction. They are the High Courts of Calcutta, Bombay, Madras, Delhi, Jammu and Kashmir and Himachal Pradesh. It is therefore the question whether the original jurisdiction of the High Court should be constituted, should be continued or abolished has been the subject matter of consideration by Justice Satish Chandra, Chief Justice of Allahabad High Court Committee, who gave his report in 1986, recommending the ordinary civil jurisdiction of the High Court should be abolished and the original civil suits pending before some of the High Court must be transferred to the City Civil Court or the District Court, having unlimited pecuniary jurisdiction. Government of India has adopted this. Government of India adopted Justice Satish Chandra Committee report, which is extracted in Justice Malimat Committee report. Government of India Ministry, Home Department, addressed a communication to the registrars of High Court dated 5th October 1988, enclosing a summary of recommendation of Satish Chandra Committee as accepted by the Government of India. Accordingly, the Government of India has accepted the following amongst others: ordinary original civil jurisdiction. The ordinary original civil jurisdiction of the High Court of Delhi, Himachal Pradesh and Jammu and Kashmir be abolished forthwith. The city civil courts in the 3 presidency terms be vested with unlimited pecuniary jurisdiction of her civil work. All the cases pending in the ordinary civil original jurisdiction of the High Court be forthwith transferred to the courts below. The same matter was again considered by Justice Malimat Committee, Chief Justice of Karnataka and Kerala High Court. The committee comprising of 3 senior Chief Justices. The committee agreed with the recommendation of Satish Chandra Committee that original civil jurisdiction of some of the High Court should be abolished. In accordance with the above recommendation of Justice Satish Chandra Committee report, by Maharashtra Act 15 of 87, original civil jurisdiction of the Bombay High Court was abolished. By a separate legislation, unlimited pecuniary civil jurisdiction was vested in the City Civil Court. The constitutionality of the said law has been upheld by Hon'ble Supreme Court by 5-judge bench, Jamshed and Gujda versus State of Maharashtra, 2005, 2 SCC 591. In order to ensure uniformity in all the High Court, Justice Malimat Committee recommended the following enactments. Prescribing for the abolition of appeal to a division bench of the High Court against the decision of order rendered by a single judge of High Court in a proceeding under Article 226 and 227 of the Constitution. Conferment of power on the High Court in the matter of deciding which category of cases under Article 226 and 227 of the Constitution should be heard by a single judge or a division bench. Another important para in Justice Malimat Committee report is hasty and imperfect legislation without adequate investigation exercised on the part of the executive regarding real need for the enactment or such law and or a proper public debate and institution consultation with expert bodies, professional association, etc. results in more institution of cases in the High Court. Then High Courts under the Government of India Act and their continuing. This is the High Courts, which were the High Court I have given the list. There are Assam High Court and about 9 High Courts. And then by virtue of Article 238(12) with the Article 214(2) of the Constitution, the highest court functioning in each part of the state prior to merger of Union of India became the High Courts established for the respective part of state under the Constitution. Similarly, there were courts or judicial commissioners in parts of state, Ajmer, Bhopal, Kutch, Vidya Pradesh, etc. These courts were abolished Under Section 51 of the State Reorganization Act, with the reorganization of state, with effect from 1st November 1956, with new high courts came into established. Union Territory of Delhi, which occupies a unique and vital position being the capital city of India, was earlier placed under the jurisdiction of the Punjab and Haryana High Court. Later, a separate High Court was established for this Union Territory. There were also courts of judicial commissioners for the Union Territory, Himachal Pradesh, Manipur and Tripura. Himachal was brought under the jurisdiction of the Delhi High Court. As a result of the reorganization of state, though various enactments enacted by Parliament and regulations made as empowered by Article 3 and 4 and other articles of the Association, the latest position regarding the number of high courts, their territorial jurisdiction, and the provisions of law under which they came into existence are mentioned in this. I have given the list. There are 24 high courts under different enactments in which different situations exist. Constitution and organization among the high courts. Under the scheme of the Constitution, the high courts occupy a very important position. The framers of the Constitution felt that Constitution and organization of the high court, if left to the provincial legislature, there might be no uniformity in the Constitution, organization and jurisdiction powers of the high court. Hence, not only the legislative subject of Constitution and organization of high court was included in the Union law, the provision for appointment of judges of the High Court, their conditions of service were laid down in the Constitution itself. Subject to these provisions, Parliament is given the power to make laws on those subjects. Under Article 216, the central authority, namely President of India, is the authority for appointing Chief Justice and judges of the High Court. As regards jurisdictional power, certain jurisdictional powers considered vital for rule of law were conferred on the High Court by the constitutional provisions. They are power to punish for contempt, the under Article 215, jurisdiction, that is power to issue writs or orders for enforcement of fundamental rights and legal rights, Article 226, supervisory jurisdiction over subordinate courts, Article 227, power to withdraw cases involving implication of Constitution from the subordinate courts, and administrative control over the staff, etc. Then Dr. Ambedkar said, we have deliberately brought in the high courts because we felt that it was necessary to bring in high courts in view of certain articles we have already passed. The only matter that is left to the provincial legislature is to fix jurisdiction of the High Court in a pecuniary way or with regard to the subject matter. The rest of the High Court is placed with the jurisdiction of the centre. Then this is next about what he said. We have already taken a particular step in regard to the High Court, that is appointment of the judge of the High Court at the hands of the President. Secondly, so far as the organization and jurisdiction is concerned, the idea is that there must be uniformity in the organization of the High Court. It's the most important court in the different parts of the country. Subject of course to the provisions of the Constitution. Therefore, in so far as the organization is concerned, with a view to emphasize the principle of uniformity and to see that there is uniformity in the different high courts. This power is transferred to the central legislature. It was originally in the state list, was transferred to the union list, high court. This power is transferred to the central legislature. It will be realized that we have high courts and high courts. There are high courts which have been functioning for several years, for a century. There are high courts which have come into being recently, and it is also proposed to bring in all the high courts in the state under the jurisdiction of the Parliament and see that there is a certain uniformity in the organization and constitution of different high courts in India. The only legislature that can function in this regard is Parliament. That is why that part is amended. In view of the changes brought about in the Constitution and the object with which the change was brought, it was necessary for the Indian Parliament to have enacted a common law for regulating the constitution, organization and general jurisdiction of all the high courts in India, and by that process achieve uniformity in the matter of constitution, organization, jurisdiction, powers of others. No such legislative action has been taken by the Union Parliament so far. In view of the inaction on the part of the Parliament, the position is some of the high courts are still functioning under the letters patent issued by more than a century ago before the British government, and some new high courts have inherited the jurisdiction of erstwhile high courts given erstwhile British government, and some new high courts have inherited the jurisdiction of the erstwhile high court given to them under the letters patent, and the jurisdiction and powers of the few other high courts regulated by laws made by Parliament in excess of its powers under Article 3 and 4 of the Constitution relating to reorganization of state legislatures. Have proceeded in some other cases, state legislatures have proceeded to make law to regulate, as I said, in Karnataka and Kerala it has happened. State legislatures, they have regulated the constitution and organization of the high court. It is high time that the Parliament, which alone is given the power to make the law regulating constitution and organization, general jurisdiction and powers of the high court, should enact a uniform law on the topic. Therefore, being fully aware of this lapse on the part of the Parliament, as a member of Parliament, I drew the attention of the Government of India of this lapse on the part of the Parliament by addressing a letter to the Government of India. I expected this lacuna would be realized and the Government of India would come forward with a bill for enacting a uniform law. Then the question is, I have, whatever I have said in Parliament, it has been published in the Forum of regulating this. But I was surprised and disappointed to get the following reply from the government. Law for Constitution of Regulation of High Court. Question number 317, Rama Jois. Will the Minister of Law and Justice be pleased to state whether even after 6 decades from the date of commencement of the Constitution, no uniform law regulating the Constitution or the has been enacted, and some of the high courts are functioning under the charters issued by the British Crown? If so, whether any action has been taken, initiated in this regard, and if so, when it would be enacted, and if not, by when the action would be initiated? Answer. The statement is in view of the provisions contained in Article 240 and 231 relating to the high courts in the state, no need has been arisen to enact a separate uniform law regulating constitution. And this is 214 to 213, this only says 226 power, 227 power. There is no regulation who should exercise single appeal should be there. Nothing is the constitutional provision is there. And the answer given is the constitutional provision itself is sufficient, therefore there is no need of law. The reading of Article 246 reading the anti-78 list, it is crystal clear that only Parliament has got exclusive power to make a law regulating the constitution and organization of all the high courts in the country. But no such law has been made. Even when this was pointed out to the government, that the government has given a reply stating that in view of Article 240 and 231 relating to the high court, no need has arisen to enact a separate uniform law regulating the constitution of the high court. Alladi Krishnaswamy in the Constituent Assembly clearly stated that the power to make a law on the topic of the constitution and organization of the high court, which was given to the state in the Government of India Act 1935, was shifted to the Union list for the purpose of enabling the Parliament to make a uniform law regulating the constitution and organization of the High Court. Not only this obligation is not discharged, but even after it was pointed out that the reply as above was given, which tantamount to the shirking of the obligation of Parliament to do so. In the absence of enacting uniform law regarding the constitution and organization of all the High Court, there are a number of differences between the rules and regulations made by the different courts or by state legislature. as pointed out above. It is high time that the Parliament should come forward with a clear and uniform law on this regard. Instead of Parliament enacting a law regulating the constitutional ordination of all the High Courts, allowing them to function under the charters issued by British Crown, even after more than 60 years after the commencement of the Constitution, and allowing rules made in by different High Courts or state legislature, indicate nothing but failure on the part of the Union government to discharge its obligations. This is a sad commentary on the functioning of our constitutional system, and there is famous statement in English that better late than never. Therefore, though there has been inordinate delay on the subject of enacting a new common law regulating constitution and ordination in all the High Court, it is the paramount duty of the Parliament to enact such a law without further delay. For these reasons, I make the following suggestion. Parliament should enact a uniform law regulating the constitution and ordination of the High Court, under which finality be given to the decisions and orders of the High Court in all ordinary civil and criminal matters, which will also serve the object of reducing the enormous burden of special petitions on the Supreme Court and enable it to devote for its time for more matters. This is my suggestion.
Thank you very much, sir, for such enlightening words. I'm sure we have a lot of takeaways from today's lecture. Now, I would request that Justice Chitatosh Mukherjee and Vice Chancellor Professor P. Ishwara Bhatt present a memento and a shawl to Justice Rama Jois. Every year, during the lecture, it has been a tradition to announce the winners of D.D. Basu essay competition that is conducted by the Constitutional Law Society. This year, the Constitutional Law Society conducted the 5th D.D. Basu essay competition, where the participants could write on any constitutional topic of contemporary importance. We received many entries from across the country, and I would now like to announce the winners of the D.D. Basu essay competition. The first prize goes to Aditya Manu Barwala from the University of Mumbai, and the second prize goes to Aditya Patnaik and Adisha Nanda. Aditya Patnaik is from NUJS, he's a 4th year student, and Adisha Nanda is an NNUO student. They co-authored a paper together on Indian Constitution and Feminism. Can I please request Mr. Aditya Patnaik to come on stage and collect the certificate? The certificate will be given to Aditya Patnaik by Dr. Saradindu Basu. I would now request Justice Chitatosh Mukherjee to open the floor for question and answer session with the audience. So audience, if you have any questions, please raise your hand. We'll pass you the mic.
Government, all this I have included, and for permanent record about my performance in Parliament, including the suggestion that uniform law should be enacted. I am presenting that book to Chitatosh Mukherjee.
Question answer
question answer session is now open for the audience. Please raise your hands in case you have any questions.
I am Shobhashati Chaudhary. I am a practicing advocate in the High Court in the original side. I have twofold questions. My first question is that there are a number of legislations which have been in the British period. For instance, the Civil Procedure Code, the Contract Act, the Transfer of Property Act, and it is still holding the field. Why are you so against the letters patent simply because it is a piece of British legislation? This is my first question. And my second question is that while you have accepted or you have supported the Malimat Committee report, none of the members of that committee had any experience in practicing in the original site and had no experience whatsoever as to how an original site functions. So without having any experience, if a committee makes a recommendation, what is the validity of that?
Question, please.
Yeah, the first question is that there are many pieces of legislation in India which was formulated or drafted by the British. For instance, the Contract Act, Transfer of Property Act, the Civil Procedure Code. We have no objections and we are still following it. So what is your objection simply because the letters patent has been done?
Everything in conformity with the Constitution. Constitution entered 78 Schedule 7. There should be a uniform law for constitution and organization of all the high courts. That is a law within the jurisdiction of the parliament. Till today, no legislation has been made. Karnataka government says they make one law, and till today it's always when the Supreme Court has said letters patent is abolished. Still, the appeal from one judge to two judges are continuing. Let there be, which is according to Constitution, and it should be in national integration from the point of view throughout the country. Uniform law should be made. And that is not what I am saying. It is recommendation of Malimat Committee, it is recommendation of Satish Chandra Committee. All that should be done. That is all. There is no question of having any opposition to this or opposition to this. Let everything be done according to the Constitution. When the Constitution says Parliament should enact a law, does it require 67 years for enacting a uniform law?
So that is precisely my question. Parliament has not yet enacted law on either the Contract Act, on either the Civil Procedure Code, or either the Transfer of Property Act. We are still following the British law.
No, whenever the question arises, this arises because some high courts.
High Court, which because of its origin in the latest patent and because of the historical reasons by which High Court came into existence of the existing law. Short answer to your question is that so long as the Parliament does not enact, that's an enabling provision in the Constitution. So long the Parliament does not enact, the latest patent and the High Courts Act and the High Court rules and practices will continue to govern the functioning. But the need for the uniformity, to what extent? Speaking myself, certainly you are right in saying the reasons why these high courts came into existence were different. For example, the Calcutta High Court came into existence by reason of fusion of two different systems. One was the Shadar Diwani courts, which is traced the origin to the Delhi Badshah, and by rule of which, by reason of Diwani, the British East India Company came to power over the functioning in the Maharashtra. So far as the High Court was concerned, its original jurisdiction, it came into existence by reason of establishment of the King's Court, starting from the Mayor's Court down to the Supreme Court, and by reason of fusion, the High Court exists. So is Bombay, so is Madras. That's why they are collectively called latest patent High Courts. With regard to the other courts, there have been now 24 of them. Their existence, their continuance have been for reasons not identical but similar. But certainly I agree with Justice Rama Jois that it is a need for bringing about uniformity. So far as the latest patent appeal is spoken of, there has been already an amendment in the code by reason of which, internal appeal in the matter of appellate jurisdiction to the High Court from the single judge's decision and second appeal to the High Court division bench has been abolished. There have been, still exist because they are in the original jurisdiction of the Calcutta High Court, so far as concerned, so is Bombay. But I quite agree with Justice Rama Jois that so far as the internal appeals, the matter of mandamus is concerned, which are not strictly governed by the Civil Procedure Code, there continues to be an anomaly. In some of the matters coming from the subordinate courts, power is exercised not under 226 but under 227. Some courts have seen that 115 of Civil Procedure Code, which gives a divisional jurisdiction to the high courts over the subordinate court, there have been provisions different. With regard to, as you know, you have said, Justice Chakravarti is here. The power of divisional jurisdiction and the Civil Procedure Code has now been curtailed, so the Calcutta High Court is concerned, by reason of giving the district courts power to decide matters arising in their own districts. So there has not been uniformity, and therefore, in spite of bringing about a consistency, uniformity after all, for the ends of justice. So far as that is concerned, there has been a measure of uniformity, but not identity in the functioning of these courts. But may I say also, in this occasion, that in the two parts of his lecture, the very learned lecture Justice Rama Jois has delivered, he has certainly shown us how one's classical knowledge about what dharma is in the Hindu law, with regard to the matter of that, the approach to the fundamental right, they have been different in India. After all, the object of any law for that any activity must be for the attainment of happiness. And he had quoted Mahatma Gandhi by saying that he had emphasized on the question of duty. I am reminded of a letter which Mahatma Gandhi had written to the Julian Huxley, who was then the Director General of the United Nations. When asked to write about the establishment of UNESCO, Mahatma Gandhi had said, "One thing which I learned from my wise but illiterate mother was that from duty only flows right." Therefore, rightly in India, the emphasis is not from the approach of claiming a right, but its performance by duty leads to happiness and also right. Therefore, our approaches are different. That's why the concept of dharma, how to be spoken, with his vast learning about the Hindu jurisprudence, and also he is the author, by the way, of the constitutional history of India. There he has pointed out that the dharma has entirely different meaning in India, compared not the mere religious practice of religious practices or rites, but it's a matter of attitude towards life. Dharma means the totality of one's duty, obligations, both spiritual, temporal, and to each other. By how to achieve happiness, how to bring about a state of where a person does perform dharma is certainly different from merely ritualistic. Therefore, the law, for that matter, any institution in this country should attain or try to bring about happiness and also enforce obligation. Therefore, that's what Raja Dharma is. Of course, in the present connotation, they continue which we now live, but there has to be a wide difference about what Raja Dharma is, or when it comes to invocation of Raja Dharma, one has spoken thing, other has said something different. Therefore, I'm not on that point. May I say that uniformity is needed, but unanimity is not possible because of origin with 24 high courts. With regard to the attempt to bring about changes about the constitutional function in the Supreme Court itself, the attempt was made to set up a separate constitutional court, for dealing with the constitutional matters, particularly to allay the danger or the difficulty which are now facing the huge accumulation of cases, more than 2 crores in this country. So these are of course, not only clearing of their areas, which seems will take not only years, but might take a century or more to dispose of it all. But therefore, it is necessary to bring about uniformity, no doubt, but with the divergence, with the differences in the country that we live, with different kind of attitudes, and there has been bound to be differences, but not contradictions in the way of thinking. Therefore, I also welcome the suggestion which Justice Rama Jois rightly made, that in the Declaration of Universal Rights, in 1948, 10th of December, possibly one omission is the happiness is not one to be, the fundamental rights or the rights which is universal right. But then, I suppose, if you're looking at the catena of rights given there, 32 of them, I believe the conjoint effect of all these rights is to achieve happiness and peace among the people. I don't wish to be long, there has been a long lecture, but we are grateful to Justice Rama Jois for having given us an inkling of the vastness of his knowledge, his command over the different aspects of dharma and religion and law, and we certainly we express our gratitude to him, and thank you very much for having asked me to make a little comment. Any other question to be answered? Shobhashaj, you have done your turn. Anybody else, I suppose? Yes, but we will not be too long. We will finish in any case when the clock strikes 1. Yes?
Sir, my name is Anipan. I teach here. I'm an assistant professor here at NUJS. So I have 2 questions leading to the whole concept that Justice Chitra Mukherjee has just said about the question of area, delay, and the trauma that people are seeking. Now, you have very rightly pointed about in your speech about the issues of uniformity and the need of Parliament to enact what was a constitutional mandate. So, in that regard, sir, I just want to seek your opinion on another provision from Article 32. As you very rightly said, sir, the Article 32 reflects the soul and heart of our Constitution, as Baba Sahib Ambedkar said. Now, in Article 32, there is a clause 3, and the clause 3 says that the power that is given to the Supreme Court for the purpose of enforcement of fundamental rights, Parliament by law can provide the same power to any other court. Now, this is a matter of inclusiveness of the justice today. People are having problems in reaching to the constitutional courts like High Court and Supreme Court, keeping in mind of the problems and challenges that are there for access to justice. So, don't you think that now the time has also come, because we are talking about inclusive growth, we are talking about inclusive judicial system. To make the judicial system more inclusive, now we need to vest the power of Article 32 to even to courts below High Court and Supreme Court, so that people can access more those courts.
My friend, with regard to the jurisdiction in matters, in matter of enforcement of fundamental rights, the Constitution in Article 32 and 226 contemplated that powers could be given to courts other than the Supreme Court in 32 and 226 High Court to other courts. But don't you think that 24 High Courts and 1 Supreme Court is enough? And I suppose, looking at the application of 226, certainly they have been able to redress grievances for which there was no redressal before the Constitution come into force. But coming to that question, litigation cannot be the ultimate aim. To promote litigation comes the ultimate aim of the people or for that matter, the state. I believe there are enough courts in the matter of number of courts, including the Supreme Court, and looking at the number of judgments which come out, I'm sure you in your teaching profession, you are also reading or making an effort to read the decisions. Don't you think that it is a plethora of decisions enough to create a confusion rather than a litigation of justice? I suppose after all, litigation, promotion of litigation should not be the ultimate aim of the country. The advancement of the country, happiness, obedience to the constitutional principles in the very preamble of the Constitution of justice, liberty, equality and fraternity, promoting the integrity of India, that should be. How to do so? I believe litigation is not the only avenue to which you reach that you go.
My latest book, Human Rights, Bharatiya Values, in which I highlighted this right to happiness, which is found in Parliament building, to be included in the Universal Declaration of Human Rights. 30 rights are there, right to happiness is not there. All the time, it is a foreword by Chief Justice Venkatachalaya. I am presenting a copy of this book to
very much. In fact, I am reminded that a few years back, NUJS had held a seminar in which a booklet was published about the Hindu law and constitution, in which a very learned article by Justice Rama Jois had appeared. I hope some of them might be written here. Do you recall having contributed an article to a journal which published about the Hindu law? Or you don't remember? You had one article here. Thank you very much in addition to our knowledge about human rights.
We have a question.
Good afternoon, sir.
Yes, come on.
This is a bit different from the topic, but I see that all of you are High Court judges, and recently we have one controversy regarding a High Court judge being held up for contempt. Justice Kannan was held up for, he is being issued notice for contempt by the Supreme Court.
Why not being? Has been issued.
He has been issued, yeah, exactly.
Right.
So there's a pre-independence case on this. Apart from that, there's been no jurisprudence on this regard. So what are your thoughts about
There has a jurisprudence about it. The principle is, question is whether a judge can be guilty of contempt of his own court. There have been decisions on this question. Right from before, even not in this country, other countries. But when in fact, the learned judge who has been hauled up for contempt is a matter of a decision by the Supreme Court and not a matter of decision at this stage by us.
Sir, one doubt I had is that the decisions which are being there are pre-independence and before the constitution came in. And after the constitution has come
So if you talk about the pre-constitution law, until new law is there, our constitution itself speaks about existing laws continuing under the constitution. So those laws continue to be, including decision pronouncement of the Privy Council, the case law decided by the High Courts, the previous court, they remain as existing law, unless they are contrary to the constitutional provisions.
Thank you, sir.
Yes.
Thank you for enlightening us today. So you mentioned about right to happiness. So if there was any such right that is to be coming into the constitution, is there any judicial mechanism to define happiness? And if not so, then how would the Honorable Court guarantee us this right?
In a lighter vein, the happiness court confers in when a person wins a case. If he loses, there is total unhappiness and sadness.
I was going through the Universal Declaration of Human Rights, and I found out that has been published by a separate document. 30 rights are there, but I found this right to happiness, which is from earliest document, and also inscribed in golden letters in the Parliament. They are not in the Universal Declaration. When it's Sarve Bhavantu Sukhinaha, Sarve Santu Niramaya, that is in the Parliament. And second, Prajasuke Sukham Rajyaha, Prajanancha Hite, 300 BC, Kautilya wrote it. That is. And every temple from Himalaya to Kanyakumari, the last is Loka Samasta Sukhino Bhavantu. This is such a prayer, why it is missing, it should be included. That is, I have stated in forward that this is such a universal principle, it should be included in the universal right. That's all. It's a suggestion. Just as I am suggesting that there should be uniform law for the High Court, because there should be uniform. When High Court single judge dismisses and they appeal to two judges, in another High Court two judges send back to single judge. Like that, different types of things are going on. Let there be uniformity in the whole country. That is all the object. For example, as I said, Karnataka Act they made, single judge writ petition and two judges hear the appeal. Who is from High Court to High Court, where is the appeal?
It is not like Caesar to Caesar, but there is a procedure for that. Anyway, there has to be a bound to different opinion, we cannot come to draw down the grounded now for the decisions.
That is for consideration.
Thank you, sir. for answering the questions. Now I would like to call upon the stage the Registrar of the University to deliver the vote of thanks.
Honorable dignitaries on the dais and off the dais, it is indeed a great privilege to deliver a vote of thanks to the dignitaries present here on the occasions of 10th Durgadas Basu Endowment Lecture. Hon'ble Justice Mukherjee is one of those few personalities of West Bengal who not only played a crucial role in the establishment of NUJS, but he consistently ensured all-round development of our university. As always, we are grateful to you, sir, for agreeing to preside over this lecture. Thank you, sir. We are amazed with the thought-provoking, enlightening and progressive thought on uniformity in the light of historical facts and traditional Indian judicial systems by Hon'ble Justice M. Rama Jois. Sir, we are greatly benefited from your today's lecture. We thank you for taking time from your busy schedule and delivering this 10th Durgadas Basu Endowment Lecture. Thank you, sir. We are thankful to Dr. Shralindu Basu not only for providing NUJS opportunity to host this endowment lecture, but also ensuring its timely organizations in last 10 years. Thank you, sir. Honorable Vice Chancellor, sir, has been the driving force behind all the programs at NUJS, including the present lecture. Thank you, sir, for all you have done to make the program successful. We are thankful to all the dignitaries of the dais, including our Treasurer, Professor Sujay Basu, Professor Subramaniam sir, Justice Chakravarti sir, Professor Venkat Rao sir, Advocate Saboshachi Chaudhary sir, and our faculty members and other dignitaries who are present here. We thank all of you. Any endowment lecture is incomplete unless we have a house full of young students who are there. So I thank our NUJS students and students from other universities who came here to hear this endowment lecture. So I thank all of you. For making the program successful, a large number of staffs, they involved in the process, students, volunteers, Constant Law Society members, everyone has taken keen interest and played certain role to make this program successful. I thank all of them. So thank you all for coming here and hearing this lecture. Thank you.
I would request all the guests and dignitaries to proceed to the room number 007. Lunch will be served there. And for all the others, tea and refreshments are being served right outside the auditorium.